Greetings from West Chicago, Illinois. My name is Glenn Gaffney of Gaffney & Gaffney PC. I'm a longstanding member of the Illinois State Bar Association Employment Law Section Council, as well as the Human Rights Section Council, as well as the DuPage County Bar Association Employment Law Section, and past president of the DuPage County Bar Association. My topic today is the top questions I receive from an employment law perspective in a pandemic. So the first question I've been getting, a common question is, if I'm an employee and I'm working and I become ill with COVID-19, is that covered by the Illinois Workers' Compensation Act so that I can get benefits? Well, previously the answer would have been probably not, because how do you prove that you sustained the injury or the illness at work? But now the Industrial Commission just recently passed a new rule. The new rule has to do with evidence of COVID-19 exposure. Now, with this new rule, there's a rebuttable presumption that if you're a frontline worker and you're working in a store or otherwise working in today's environment under the shelter-at-home rule, and you become ill with COVID-19, there's a rebuttable presumption that you are eligible for workers' compensation benefits, and the employer would have to prove that you did not sustain the illness from work. So the short answer is yes, you probably are covered for Workers' Compensation Act benefits. Another common question I often get is who's responsible to pay for the personal protective equipment? Well, beginning January 1 of 2019, the Illinois passed a law requiring employers to pay for all necessary equipment, regardless of what it is. So this would include personal protective equipment. This may also include what you need to do to shelter in place and still continue to work. The employer should be responsible to cover any additional expenses you incur in order to work from home, as well as any additional expenses necessary for you to protect yourself in the workplace. So another question I've been getting is, if I or a member of my family become ill with the virus, do I have any protection under the Family Medical Leave Act? Well, first of all, let's be clear. The Family Medical Leave Act only applies to certain employers and employees who've worked for over a year and have the requisite number of hours. The employer size also is an issue. It covers employers who have 50 or more employees within a 75-mile radius. Typically, FMLA leave has always been job protection, but without pay. You protect your benefits during the leave, but you don't protect your pay. You also are protected from the standpoint that you will have a job available for you when you return, as long as you can return within 12 weeks. But now, recently with the new CARES Act, there's been some changes to the FMLA, which enables employees to receive some limited amount of pay while out on FMLA. It's too detailed to get through all those issues right now, but be aware that if you are out on leave because of the virus, you may be eligible for FMLA benefits under this new act that's specifically applicable to this current pandemic state of affairs. Another question I've been getting is, what about privacy? What about the privacy laws when we talk about this COVID-19 virus? Well, certainly the Americans with Disabilities Act covers employee privacy when it comes to healthcare issues. Now, people talk about HIPAA, but really HIPAA applies to hospitals, doctors, medical providers, insurance companies. But in an employment setting, we do have the Americans with Disabilities Act as well as the Illinois Human Rights Act. And those acts specifically provide that employee privacy is protected, and only when an employer has a need to know reason can they get into healthcare issues. Now, with this current virus, it is potentially what they call a direct threat. As a direct threat, the employer has a right to determine whether or not you would be a threat in the work environment. However, the employer has a right to know, but not everybody in the workplace. So if you do become ill with COVID-19, the employer should not be broadcasting that to other employees. They should keep it private, but they do have a right to know, and they certainly would have a right to require you to work from home if you are potentially a direct threat to others in the work environment. Another common question I've been getting is employees who state that they're afraid to go to work. Their employer is requiring them to show up, or the employer wants them to show up for work, but the employee is fearful. Possibly the employee has someone in the family who has a serious medical condition, or is aged, or they're afraid to expose their young children. It's a very complex question, and one of the issues is whether or not the employee is entitled to a reasonable accommodation under the ADA or the Illinois Human Rights Act. So, for example, if an employee himself or herself has an underlying medical condition, the employee can provide notice to the employer, preferably supported by a doctor's note, that the employee has this underlying medical condition which makes potential exposure to the virus very problematic or even life-threatening, which would enable the employee to state that they're entitled to a reasonable accommodation that they be able to work from home or be on FMLA leave of absence. So from that standpoint, the employee does have some level of protection. It can be more problematic if the employee doesn't have a justifiable basis for the fear, such as a need to protect an underlying medical condition or a need to protect someone in the household with an underlying medical condition. So there's crosshairs here between the FMLA, the ADA, and the Illinois Human Rights Act, all of which have to be taken into consideration. So then there is, what about overtime pay for employees that are working from home? How do we determine the number of hours that employees are working? Well, first of all, salaried employees receive their salary regardless of the hours that they work. And typically the employer doesn't necessarily keep track of salaried employees. That would be what we would call FLSA exempt employees. Now, an employer can get in trouble sometimes if they reduce or don't pay a salaried exempt employee for time off for reasons such as this. But another question comes in for non-exempt employees, administrative employees, secretary type employees, employees that are working, but they're otherwise a true hourly rate employee. For those employees, they need to keep track of their hours working from home, just like they would at work. A lot of times you can log in or show that you're working through computer usage, emails, text messages, in order for you to establish the number of hours you're working during the course of a week. And of course, for those what we call non-exempt hourly rate employees, if you are working more than 40 hours a week, you're logging in your time both during the day or at night. Whenever you're working, log in your time appropriately and submit your hours. If you're working more than 40 hours a week, then obviously you're entitled to time and a half for your overtime wages, just as if you were working in the place of employment. Another question is, what is the difference between a layoff, a furlough, or a termination? So a layoff and a furlough are synonymous, and essentially they mean that the employee is not terminated from the company permanently, but they're on a temporary leave of absence, whether it's paid or unpaid, typically unpaid. During a layoff or a furlough, the employee's benefits should all stay in place and remain as if the employee was working. They're subject then to recall. Obviously with a termination, then the employee is entitled to be paid out all their paid time off or vacation pay, and the employee is certainly eligible for unemployment compensation benefits. The issue then becomes, what about unemployment compensation benefits for an employee who is on furlough or a leave of absence, unpaid leave of absence, that are subject to recall? Well, now the Illinois Department of Employment Security has passed rules saying that these employees certainly are entitled to benefits if you're on an unpaid leave of absence. And with the new rule applicable to this pandemic situation, the employee does not have to show that they're out looking for another job, which normally an employee would have to do, because the employee is being told that within a relatively undefined, but yet not overly lengthy period of time, they're subject to recall. So if you're subject to recall, you're on layoff or furlough, you are entitled to unemployment compensation benefits, and they waive the obligation of the employee to actively search for work, which you would have to do to qualify for unemployment compensation benefits if you actually were terminated. Well, thank you for watching. This is a rapidly evolving area. There's new rules, regulations being passed all the time. There are additional resources available for you on the ISBA website. There's also a number of upcoming seminars. I invite you to tune into those as well. But stay healthy, stay safe, and hope to see you again soon.